You've probably done it 100 times, right? Photocopied a page from a book. It feels like nothing, just a totally normal part of being a student. But what if I told you that simple act, pressing a button on a copy machine, ignited a massive legal war? A war that put giant global publishers up against one tiny campus shop. This is the story of how a single photocopy case changed the rules for everyone. And it all kicks off with a really simple question.
Okay, let's put you in the picture. You need one chapter from a textbook that costs a ton of money. So you go to the copy shop and run off the pages you need. Did you just break the law? It seems like it should be a simple yes or no, but the answer gets right to the heart of this huge debate about who owns knowledge and what it should cost. Now, on paper, the law seems pretty straightforward. Copyright basically says the person who created something gets to control it. So if you copy their work without asking, that's called infringement. That's the bedrock rule that protects authors and publishers. Seems pretty black and white.
Yeah, about that. The law isn't a blunt instrument. It's actually got these little trap doors, these exceptions for situations where copying is allowed for the greater good. And you know what one of the biggest exceptions is? Education. And this is where that simple black and white rule explodes into 1,000 shades of gray. This is where our story really gets interesting.
That educational exception is the absolute core of this whole thing. We're zooming in on Delhi University, where a small, kind of ordinary photocopy shop suddenly found itself in the middle of a legal firestorm, a case that would become known as the Rameshwari photocopy case.
So who are the players in this showdown? On one side, you have Rameshwari Photocopy Services. Just a little shop, but it was officially licensed to be right there on campus. And what were they doing? They were making course packets, basically custom textbooks made by bundling chapters from lots of different expensive books and selling them cheap to students. And on the other side of the courtroom? Oh, just some of the biggest academic publishers on the planet. We're talking Oxford University Press, among others. A real David and Goliath situation. And this set the stage for a massive fight. This was never just about one little shop. It was really a battle over a much bigger idea. When a publisher's right to make money clashes with a student's need to learn, who wins?
The whole legal battle really came down to two completely opposite ways of looking at the law. The publisher's argument was simple. Look, this is a business. A for-profit shop is copying our books and selling them. That's textbook copyright infringement. End of story. But the shop fired back with a really powerful defense. They pointed to Section 52 of India's Copyright Act, that educational exception we talked about. Their argument was, whoa, hold on. We're not infringing. We're just helping the university do its job of teaching students.
So the battle lines were drawn. You have what looks like obvious commercial copying on one side and a powerful legal shield for education on the other. Everyone was on the edge of their seats, waiting to see which way the court would go. So, who won? Was this little shop a pirate, stealing from authors? Or was it providing a crucial service for students? I mean, the future of how millions of students get their learning materials was literally hanging on this one decision. And the verdict? It was a bombshell. The court sided with the photocopy shop. In a decision that just sent shockwaves everywhere, the court said that making these course packets was not copyright infringement. I mean, that verdict had so many people scratching their heads. How? How can a commercial business copy textbooks and sell them legally? To get it, we really have to dive into the court's reasoning, which was surprisingly practical. The court's entire decision really came down to how it defined three little words in the law. First, the word teacher. The court said this doesn't just mean the one person standing at the front of the class. It means the whole university, the entire institution. Second, instruction. They decided that's not just the lecture itself, but the whole process, creating the syllabus, assigning readings, giving students the materials they need. And finally, the word reproduce. The court pointed out that the law actually puts no limit on the number of copies you can make for that instruction. But beyond the legal definitions, the court just used some good old-fashioned common sense. The judges basically said, let's be real, we can't expect a professor to go out and buy a huge photocopier to make materials for hundreds of students. Of course they're going to go to a copy shop. The court saw the shop as just a tool, an extension of the university's mission to teach. So this decision was so much bigger than just one win for one shop in Delhi. This ruling created ripples that spread across the entire world of education, setting a huge precedent that's still incredibly important today. So what are the big takeaways from all this? First, it put a huge stamp of approval on the idea that education gets special treatment under copyright law. Second, it sent a clear message that a student's ability to access knowledge at an affordable price is a major priority. And finally, it gave us a much clearer and broader idea of what's considered fair use or fair dealing in a university setting, giving a lot more power to students and teachers.
And all of this leaves us with the big, messy question that's at the center of this whole thing. Look, creating books and research costs real money, and authors absolutely deserve to get paid for their work. But at the same time, should knowledge be locked behind a paywall so high that the people who need it most, students, can't get to it? How do we find that balance? The Rameshwari case gave us one powerful answer, but it's a debate that's still very much alive today.